Having an IP strategy is more than just having a patent portfolio. The patent portfolio needs to have some sort of strategy behind it. There are a few ways to protect patents. One of them is to wait for the inventors to come to you with an idea, but really the best way is to look at the company's objectives, figure out what the company is trying to do, and make sure you're protecting that. The other thing you want to think about is how to protect the particular innovations. If it's a pioneering innovation versus an incremental improvement, doesn't necessarily mean one patent is going to fit the bill. Sometimes you want multiple patents, whether it's covering just a small piece of it. Sometimes it's a broader patent covering more white space that's out there because more white space is available. When you think about building the fence around your property, it sometimes helps to have lots of little posts to protect that property, as opposed to just one broad patent, which might be easier to knock out. So when we want to protect a pioneering idea, we want to think about the different ways we could protect it, how it could be challenged, and the other areas it could be used, so that we could really have a solid type of strategy to prevent competitors from coming into that space. There's an evolving standard for patent-eligible subject matter in the business method space. So if you're trying to protect innovations in the financial services area, whether it's for banks, insurance companies, other vendors in that space, it really is important to make sure that you're aware of this standard for what is patent-eligible subject matter, what can be patented. The Supreme Court has said that anything tied to a machine can be patented. So it's really important to think of these innovations not as business methods that are being performed by people, but rather as software innovations that are being performed by a computer. So as we draft these applications, we want to think of them as software innovations and think about what we need to do to describe them adequately now for protection now and protection down the road. Every country around the world pretty much treats patents differently than other countries. They're attempting to harmonize the systems, but a business method patent in the US might not be considered patentable in a place like Europe. So it's important to seek local counsel that can give you guidance on what you need to do to either tailor your application for that jurisdiction or to tell you this is not going to be a worthwhile effort. There are some procedures, such as the patent prosecution highway, that can allow you to expedite examination in one place once you have an allowed patent application in another location. So we want to think about where you could get protection, how you could get protection in those places, and do you really need to spend the money to get protection there? All sorts of considerations that can affect your bottom line and could affect your ability to compete around the world. When looking to acquire a patent portfolio, there are many things we need to look at. First, we want to look at whether the person saying they own it actually does own it. Then we're going to look at what they have. Do they have patent applications? Do they have issued patents? For patent applications, what's still pending? What kind of challenges are they facing? What are the chances that it's going to be patentable? If it is patentable, what are you going to be able to use it for? Are we going to be able to cover what your competitors are doing? Does it cover the product that you have? For issued patents, it's a similar inquiry. Are these patents actually valid? Are we aware of any prior art that could invalidate these patents? Are we going to be able to enforce these patents? Do they really cover what you think they cover? Let's assess the portfolio the way a challenger would, so that when you want to purchase it, we can help guide you as to what kind of risks you're actually acquiring.